the legal instrument related to uh, property transactions and related items. So the objectives of discussion is to identify the transfer of movable, immovable properties. Second one, to identify the application of POFO. Third one, its restrictions. Then deed as an instrument, its value. Then types and parts of the deed, registration, pedigree, title report, caveat, list pendants, and the importance of conveyances to a value, how it applies, conveyancing part, the legal side, and the valuation provisional viewpoints. So we'll discuss as the first part of the lecture, then after that we'll discuss the application of this and what are the advantages available for a valuer in this valuation practice as far as the legal instrument of deed is concerned. So that's one of the important things that we are going to discuss. And the second chapter is the, what do you call this one? One of the modes of acquisition of ownership, that is, what do you call the Land Acquisition Act. So this is also coming under one of the modes of acquisition, that's deed. Because now early stage we understood, we identified what are the modes of acquisition of ownership of property, immobile property. First one was the occupatio, then traditio. Then after that we discussed the accession, accessio. Then after that, Land Acquisition Act, we are going to do it today. And also the purchase. So the basis of purchase is the legal instrument. It's a requirement by law. So I am developing the deed from the as mode of one of the modes of acquisition of property and its instrument. So the transactions related to immovable property. First of all, I was mentioning you that there are many main two types of property. First is immovable, second is movable. So as far as the transfer or the transaction of movable and immovable, there are so many differences. The main difference is when you are transferring a movable property, you have to use the legal document of SOGO, that is sale of goods ordinance. But as far as the immovable property is concerned, what is the instrument? What is the legal instrument or the statute? Prevention of fraud ordinance. So you can say movable is governed by SOGO. You can say M-SOGO. Then immovable, IM-POFO, Prevention of Fraud Ordinance. So those provisions are applicable in the transaction procedure of these two types of properties that we have to understand. Don't mix it up, right? Then the governing statute is, as I told you, the Prevention of Fraud Ordinance. Especially the section 2 is very important for a valuer to identify even the validity of a deed. That's very important, right? Section 2 says, section 2 for a valid sale, purchase. Purchase means one of the modes of acquisition, as I mentioned. Transfer, same. Mortgage or other immovable property contract or agreement should be. Agreement means sometimes there can be a sales agreement. When you go to the field, sometimes the client will give you the sales agreement instead of what you call uh, deed. Sometimes they give deed of declaration instead of the deed. So like that, you should have a very good eye to identify the nature of the instrument related to the particular property you are going to visit and the value and to value. So according to the Prevention of Fraud Ordinance, there are certain things that are essential for a valid transaction of immovable property. Right? Otherwise, that legal instrument is null and void. So, first one is it should be in writing. You can't just sell a land verbally. මේ ඉඩම අරගෙන මෙච්චර දෙන්න කියලා සල්ලි අරගත්තට ඒක ට්‍රාන්ස්ෆර් එක මාරු වෙන්නේ නැහැ. Okay. But in case of immobile property governed by SOGO, of course you can give money and take a receipt and give the good to that person, the purchaser. As far as the immobile property is concerned, it should be in writing. There's no second word. You can't change that. And it should be written in a good paper, right? That's also very important. Durable paper. Then signed by parties making the same or anyone authorized by him. So signatures are very important. The related parties should sign, physically present and sign. Or sometimes if he can't come, he can authorize someone else to come and sign on his behalf. What is the example? Attorney power. I'll give my attorney power. You go and sign this. I'll do it at the end of the session. What is attorney power and all. So anyway, if I give my power to someone else to act on my behalf, that is okay according to the section 2 of the act. The third one, the signatures should be placed or fixed in the presence of a notary public. That's also essential. So if you are signing the document here and the notary is somewhere else, then that document is null and void. Okay, there are certain cases, related cases also. Now I can remember that one Fernando versus Fernando. In that case, what happened was one person was in the hospital. So some fellows went there and get the signature. Sorry, notary public was there, but certain witnesses, සාක්ෂිකාරයෝ වෙන වෙන තැන්වල හිටියේ. So they signed the document not in the presence of the notary public and not at the same time. So the requirement is it should be signed by the persons who are signing in the presence of the notary public and at the same time. So our case එකේදී මොකක්ද උනේ? As I told you, the documents are signed not in the presence of notary public and not at the same time and the same place. So it was declared null and void. So fraudulent document maybe. Then, so those are the requirements. Otherwise, this legal document will be null and void. So section 3(1) of the Prevention of Fraud Ordinance states that section 2 will not apply to any transaction or agreement for paddy or chain cultivation for a period not exceeding 12 months. If the consideration is to give a share of the produce thereto. දැන් chain cultivation වගේ ආවද මාස 12කට අඩු කාලයකට ගන්න agreements වලට අවශ්‍ය වෙන්නේ according to the original PF4 to follow the provision of fraud ordinance, it should be more than 12 months. Even it is a chain cultivation. Less than that, then you should not follow the provisions given in the Prevention of Fraud Ordinance. Section 4 මොකක්ද කියන්නේ? Section 4 states that last will and codicil do not come under the effect of Section 2. අද last will එක කියන්නේ අන්තිම කැමති පත්‍රයක් වගේ දෙයක්. ඒක not coming, yeah, it is not coming under this because sometimes even in the absence of the notary public, or 5 witnesses can sign the last will. So those are the exceptions to the provision. Okay, that is the general introduction. And yeah, now simply we'll try to understand what are the types of deeds. What are the types? First one is, excuse me. First one is deed of transfer. සාමාන්‍යයෙන් ගත්තොත් අපි විකුණුම් කරා කියන්නේ deed of transfers. So ඒකට provisions apply වෙනවා. What is transfer? This is a sort of contract between vendor and vendee. Right? So when you are going to do the law of contract, we'll try to connect to this area too. But anyway, the contract should be a valid one. It should be between more than one party. So 2 parties should be there. And the basic principle of contract is the meeting of minds. Sit එක්තැනීමක් වෙන්න ඕනේ contract එකක් ඇති වෙන්න, otherwise it will never come. Right? There can be conditions in the transfer or the contract. Right? So both parties should compromise, right, with their consents to accept those conditions and commitments. Okay. So then deed of gift. Deed of gift or revocation. Deed of gift means there's a sort of transfer, but it's a gift, in the nature of gift. The first one is the deed of විකුණුම් කරයක්, දෙවෙනි එක තෑගි ඔප්පුවක්. සිංහලෙන් කතා කරා. Right? The deed of gift, that's also ඒකේ මුදල් බදුවල පොඩි වෙනසක් යන පස්සේ කතා කරන්න. But there also same principle is governed by the provision of prevention of fraud ordinance, because deed of gift, we are talking about the immovable properties. Right? වෙන තෑග්ගක් දෙනවා නම් ඒකට අවශ්‍ය වෙන්නේ නැහැ. මම ඉස්සෙල්ලා කියපු විදිහට ඒකට යන්න ඕන වෙන statute එකක්. Then lease agreement. This is also very important for the value. Why? Because when you are valuing the leasehold interest or whatever, then you must be well conversant about the lease agreement. You got the point. So you must find out what are the conditions there, and what is the interest he has. Leasehold interest. What is the nature of that interest? Everything has to be studied very well in a lease agreement. So you better find out some lease agreements and try to understand, read the conditions and other things, and all other commitments, and try to understand the nature of the interest and what is the interest that you have to value. That is the most important thing. What is the interest you have to value? Okay, then agreement to sell or transfer. So there can be an agreement. So that's also coming under the provisions of prevention of fraud or understand, right? Sometimes we couldn't sell, I will correct, right? We can give some sales agreement. So the sales agreement That's also coming under that. Then deed of partition. So partition, that means partition and කොයි වගේ වෙලාවටද? හුඟක් වෙලාවට එන්නේ when there is co-ownership. Right? There are more than one owner to one particular land. They are owning a share of the property. Right? Now say one person is there. Sorry. Yeah, he died. Before dying, he write a last will. Right? This land should go to my two sons and it should be equally divided, equally given as far as the ownership is concerned. Then what happened? Say this is 20% land, then there are two co-owners. වැරදි ඉස්සලා බෙදලා වෙන් කරලා දුන්නේ නැහැ. They said දෙන්නටම අයිති. එතකොට half share එකක් එක්කෙනෙකුට කරනත් අනිත් එක half share එක. අනිත් එක කෙනාට යනවා. So in a situation like that, these two fellows can get together and write a partition deed. Plan එකක් හදලා ඒ plan එකට අනුව ඔප්පු ලියලා partition අයිතියක් ලබා ගන්න පුළුවන්. අයිතියක් ලබා ගන්න පුළුවන් partition deed එක මගින්. Okay. Another instance where the deed of partition or the partition deed comes into the scene is that there are three co-owners. සහ අයිතිකරු තුන් දෙනෙක් ඉන්නවා. They don't like to write the partition deeds among them because they don't like. They have some quarrels and other things. Then in that case, what will happen? They will have to go to courts and get the matter resolved. And after that only, court will allow them to get partition deeds. So once the partition deed is given, there is a very clear title. So when you are valuing a property, if the deed is coming from a partition action, then there's no encumbrances or any defects in that particular title. You have to understand that very carefully. Right. In valuing that, the interest is there, then you can value it without any hesitation. Deed of exchange can. Exchange can humaru. Right. I have land A, 10 purchase. My brother has 10 purchase land. So we want to get this exchange. Then we'll have to write deed of exchange and get the ownerships transferred. That is the legal method of transferring the ownership. Deed of rectification. Rectification can varada nivarada kirime ඔප්පුවක්. Right? In certain cases, in a deed, sort of some shortcomings are there. So we'll have to rectify that by the notary public who attested the deed. Rectification. So sometimes when you go through the deed, you can see there's a deed of rectification. That means that is also very sure, very clear. It is very clear to understand the interest. Then mortgage bond. So for example, I want to get a loan from a bank. So I secure my land or I mortgage my land to the bank. Mr. Bank, you can keep this, but give me 1 million rupees. So you can just give, right? Then bank will have to go through the title and make it clear. Then if the title is not clear, then ask that man to get the title insurance. After that only, they will write a mortgage bond. There are also the mortgagor and mortgagee. Mortgagor කියන්නේ mortgage කරන එක කියලා. මම loan එකක් කරනවා I am mortgage. Then bank is the mortgagee. So that's also a sort of contract. Now you can see so how law connects from different areas. Right now all contract law coming here now. Right? So even in a sort of building contract, there are two parties, client and the contract. Then in that case, then again there's a meeting of minds and their conditions are there. They agree each other, then write a one. That's a legal document. For example, now I want to mortgage my land to the bank. So I got 1 million rupees. They accepted my security and the valuation also there enough. Then what happened is they will call me and give 1 million rupees. You keep it, but you must pay, right, 10,000 rupees per month without fail. If you are not paying regularly, or if there's a default for more than 3 installments, we have to sell your property and collect our money. So that is the principle under mortgage law, right? So that's there. So that is the implementation of the mortgage bond implementation. In the absence of implementation in the sense at the default, right? Not otherwise. So at the default, then bank will sell that property because that power is given in that, sorry, the deed, bond. It's a legal document. So a condition එකක් තියෙනවා. මෙච්චර කාලයක් ගෙවුවේ නැත්නම් අපි මේක විකුණ ගන්නවා. No one can challenge. Sometimes some banks have the parate powers. That means they can sell it. In certain banks, they don't have parate powers. They have to go to the courts, get the permission, and sell the property. So those things are there. That is one. Then deed of release. So that's also one. When the bond is over, they can get the deed from them. That is that information. Okay. Then before going to this, I'll request all of you to go home and get hold of a deed and try to find out its parts. What are the parts of a deed? That's very important, right? So if you know all these things, you can just read the deed and get the idea of the interest. Yeah, now there are, if you get a deed, now I have one deed here. First part is exodium, recital, operation, then habendum, covenant, and testimony. So there are 6 parts. Sometimes මේවා එක එකටම නෑ සමහර voice ලා මේක couple කරලා ලියන්න පුළුවන්. But anyway, everything is there. Everything should be there for a perfect deed. So first one is exodium. Exodium එකේ ඔයගොල්ලන් දකින්න නැති උනක් කළාට තියෙනවා. To all to whom this present shall come. ඒ වාක්‍යය ගන්න සමාන. To whom, to all to whom this presence shall come. සිංහලෙන් දාන සියලු දෙනාම දැනගත යුතුයි. So that is the identification of the okay. Right. Then the second part is recital. Recital means මෙතන එක principle එකක් තියෙනවා. If you don't have the ownership, you can't sell that. That is the accepted rule. So හොරහොප්පු හදාගෙන වික්කොත් that's a fraud or whatever. Then he will be penalized. Right. Then okay, now recital says from whom this land came to me. Deed එකේම තියෙනවා කියලා. Recital කියන case එකේ අපිට මේකත් ගන්න පුළුවන්. ඒ විස්තරෙත් ගන්න පුළුවන්. කාගෙන්ද මෙයාට මේ ඉඩම ඇවිල්ලා තියෙන්නේ කොහොමද මොන ඩීඩ් එකෙන්ද? ඒක විස්තරය මෙතන දීලා තියෙනවා. Okay, so you can understand that also. That means that's a sort of history, short history of the land, or the title. Make කොහොමදාරේ කියන එක. That is there. Then මේකෙත් දැන් ගත්තොත් දැන් මේ මගේ අතේ තියෙන ඩීඩ් එකෙත් තියෙනවා මේකේ තියෙන එක්කෙනාගේ නමට කියන්නේ ඔදෙලියා රෙසිඩෙන්සස් අනික එයාට මේක කාගෙන්ද මේ කාගේ කොහොමද ආවේ කාගෙන්ද ආවේ මොන ඩීඩ් එකෙන්ද ආවේ කවුරු ලියපු ඩීඩ් එකෙන්ද ආවේ that is given in the so ඔයගොල්ලන්ට දැන් පේන සෑහෙන ඉන්ෆර්මේෂන් එකක් ගන්න පුළුවන් මේකේ පසු අයිතිය ගැන මේක කියනවා අපිට ලෑන්ඩ් රෙජිස්ටර් එකට ගියොත් ගන්න පුළුවන් අවුරුදු 30 40ක ඉතිහාසය එක ඩීඩ් එකකින් ගන්න පුළුවන් පොඩි කාලයක් සමහරවිට මේ ඩීඩ් එක අවුරුදු 15ක් ඉස්සර පරණ එකක් වෙන්න පුළුවන් අවුරුදු 15ට ඉස්සෙල්ලා මට මේක ඇවිල්ලා තියෙනවා so that's a sort of clear title then again මේක අවුරුදු 30කට ඉස්සෙල්ලා මට ඇවිල්ලා තියෙනවා it was a transaction nothing so in a situation like that you can identify the nature of the title too from the deed that is from the recital part that you can understand that right next is the operation part this is very important for the professionals consideration all deed එකක් ගත්තාම ඒ deed එකේ තියෙනවා මේ වටිනාකම that is called the consideration සිංහලෙන් කියන්නේ ප්‍රතිස්ථාප එතකොට දැන් මේ deed එකේ තියෙනවා මේ transaction එක වෙලා තියෙන්නේ for 22,426,000 so this is also a very vital fact for a valuer in doing his valuation right so this is a very good evidence for your valuation for example now this land has been purchased last month consideration is 1 million so that's a good evidence for the valuer to make his valuation then description also given in the deed deed එකේ තියෙනවා schedule කියලා එකක් උපලේඛනය කියලා එකක් තියෙනවා ඒක අපි බලපුවම අපිට තේරෙනවා ඒ උපලේඛනේ තියෙනවා ඉඩම විස්තරය මොනවද තියෙන්නේ name of the land right this schedule the name of the land Alutwatta bearing number 154 right together with the residential house so those details are also there in the deed you may never have noticed this right then again the assessment number is there name of land is there then what is the lot number කැබලියා කියන්නේ මොකක්ද ඊළඟට plan number එක මොකක්ද plan number එකේ date එක මොකක්ද plan number එකේ survey එක so those important things are there say for example if the plan is for 20 years then you can't accept that plan especially for mortgage purposes you can ask that man to get a new survey done so this information also there you can extract that from this then after that they give the village name of the village කොහෙද මේක පිටලා තියෙන්නේ location also right then road what is the road location right then Grama Niladhari division then after that local authority Pradesh Sabha or Nagara Sabha Mahanagara Sabha ඔක්කොම මෙතන තියෙනවා deed එකෙන් ගන්න පුළුවන් මේ කොටස. Then after that they give the district and the province. So that is the full description of the location is given in the deed. And you don't find it in the survey plan. Survey plan gives its name, number, surveyor's name, everything. And also it gives, like in the deed, it gives from where this survey came. මේකට ඉස්සෙල්ලා තියෙන මේක undivided sorry මේක this is a subdivision of method, this is a amalgamation of some other lands, so that connection is there. ඒකෙන් තමයි මේ plan එක ඇඳලා තියෙන්නේ. You got the point? So that in the deed also it gives how the title came to you. Survey plan says from where this survey plan came. So that's a good linkage, combination for a value to understand. It's a very interesting area, right? Then they give the nature of the transfer. Okay, they know if they make a transfer, that time make a gift, right? Make exchange, everything is given there. So now, up to now, you can see as a value, what are the important facts that you can extract from it up to now, right? So these are the part. This is the third part, operation part. One thing I must mention here is that what is mentioned in the operation part supersedes all the other words and the terms given in other parts of the deed. මේක තමයි operation part එක තමයි supreme. මේකේ කියන දෙයක් පොඩ්ඩක් වෙනස් වෙලා තව තැනක කියුණා නම් we have to go by the operation part. It's a very important part. So that also you must understand, right? The next part is habendum clause. This should embody all the rights and privileges of the property. එතකොට අලුත් ඕනට යන privileges, rights, everything should be mentioned in this section. ඒ වගේම සමහරවිට ඒකේ mention වෙනවා මේකේ මොකක් හරි ප්‍රශ්නයක් වුණොත් මේ විකුණන එක්කෙනා තවදුරටත් ගත් එක්කෙනාව බලා ගන්නවා කියන අදහස එනවා. ඒ වගේම යාට යන වරප්‍රසාද මොනවද? අයිතීන් මොනවද කියන එක පැහැදිලිව ලියන්න ඕන abandon clause එක. Understand? So now we have understood very important things. Exordium, recital, operation part, consideration, description, and the nature of transfer. Very, very important for the professionals. Not only the values, all the other professionals, very important. Then number 5, covenant clause, the obligations. There are some things that are obligation nature. This is that the parties to the deed enter into deed promises to other party that something is or not done already or shall not be done afterwards. So a covenant at first that parties, say for example, parties promise themselves, right, to do something or not to do something or refrain from doing something after the transaction is done. Then a testimonial clause that is also given in the end of the deed. At the end you get that. At the end you get that. Yeah, notary say and do hereby further I certify that and attest that the stamp duty rupees such and such payable to the purchaser on behalf for the the amount mentioned, that the same amount mentioned in the instrument, and this was paid in front of me, that type of thing, and he will attest that. Attestation එක තව උනාට දකින්න පුළුවන්. Notary public ගානවා එයාගේ මම කොහෙද මගේ මේ ගාන මේක අපි Mr. So and so, Notary Public of Colombo in the Democratic Socialist Republic of Sri Lanka hereby certified. Like that, he will certify that. So that is the end of, and at the end of the day, end of the document, Notary Public say which I attest and put the signature, and at the same time is seal as a must. Then after that, put the date. Date is also very important because sometimes when you're finding sales, the date is very important. We have to get hold of some recent sales. So by looking at the deed, you can find out when this transaction was done. So this is the effective date, right? Date of attestation will be the relevant date of the deed. That's it. So now, in a nutshell, you have some idea about what deed is. So get out of number of reads, English, Sinhala, Tamil, or whatever, and try to understand. Right? All these parts they are included, but sometimes they are hidden or they are mixed up. But anyway, everything should be there for a perfect or complete deed. That is about deed. Another thing I couldn't tell you, in the schedule, they give the boundaries also. Boundaries are given. Now we are north, east, south, west. So we have to check the boundaries of the deed and the boundaries given in the survey plan. For a perfect identification of the security, these two should tally. Right? Sometimes, due to certain reasons, it may not, but generally, if it's a recent deed and the recent survey plan, definitely the boundaries should be same. Otherwise, there can be some boundary dispute or whatever, then we'll have to go into that and find out what the position is. So for the identification of the property security or the property that you are going to value is guided by the deed 2, guided by the survey plan 2. Because the survey plan also given in the deed, right? And boundaries of the survey plan or the original boundaries of that particular land is given in the deed. So now you can see there are certain combinations or linkage between deed and the survey plan. Now for a validity of a deed, the stamps should be affixed in a deed. Otherwise, that is not a valid one. Here I have put some, this slide I put some rates, applicable rates, depending on the value. එතකොට මුද්දර බදු ගහන්න ඕන, මුද්දර ගාස්තු ගහන්න ඕන, වටිනාකම අනුව. ඒ වටිනාකම තක්සේරු කරන වටිනාකමට මුද්දර ගාස්තු ගණනය කරන්නේ මේ පිළිවෙලට up to 1 million, 1 lakh, 3%, 3%, right? Of value. That means 3,000 per 1 lakh. For additional 1 lakh, right? ලක්ෂ දෙකක් වුණා නම් දෙවෙනි ලක්ෂයට යනවා 4,000, 4%. Right. එතකොට දැන් example එකක් මම කිව්වොත් property එක රුපියල් 2,500,000 වෙනවා නම් you will be able to calculate the amount of stamp duty. You got the point? All right. So the valuation is given in the deed. So according to that, the stamp duty should be calculated and that should be pasted on the relevant deed. So deed is in 3 copies, but in one, this thing, you have to paste those things. Then that is, I'm talking about the transfer. Stamp duty for a deed of transfer. If it is a deed of gift, gift එකේදී up to 1 lakh, 3%, that is 3,000 rupees. Additional 1 lakh, only 2%, unlike 4% in the transfer. There you get 2,000 rupees. For a deed of exchange, stamp duty to be paid for the difference. සමහරට deed of exchange එක හුමා රුප්පුවකදී අර අමතරව වැඩි වෙන ගානට මේ රේට්ස් වලට අනුව ගෙවන්න වෙනවා. Deed of transfer එකේ තියෙන රේට්ස් වලට අනුව ගෙවන්න වෙනවා stamp duty. Now, for example, if you take 10, the value is 6,000 or 600,000, then value should be how much? First 1 lakh, 3,000, ඊට පස්සේ අනිත් ලක්ෂ 5ට 4 ගාන. ඒ කියන්නේ 20ක් එනවා. 20යි 3යි 23,000 stamp duty should be paid for that. That is for a transfer. If it is a deed of gift, what will happen? That 6,000 rupees. First 100,000, 3,000. Then additional 500,000, 10,000. 5 to 2, 10. So 10, 3, 13. You can see the difference. Here we got, I think, 23,000. You get 13,000. So what I want to highlight here is that for a deed of gift, stamp duty is less than the normal transfer. That is given the Stamp Duty Act. Okay. මේ slide එකේ මම දාලා තියෙන ඔයගොල්ලන්ට අවශ්‍ය information, what can we take from a deed, right? Information for a value, right? Like this, everything is there. මම discuss pretty ඔක්කොම location එක මම කතා කරා. Nature of deed, මොකක්ද deed එක? Nature of ownership, leasehold act මොකක්ද? Undivided life interest, subject to life interest. What is life interest? ජීවිත භුක්තිය. දැන් ඒ කියන පුද්ගලයා ඔගේ ජීවිත භුක්තිය තියාගෙන දරුවට ලියනවා. Right? Actually, the owner is the child, but this man has the right to possess that. To possess that. Take a භුක්ති විඳින්න විතරයි. Possess that until he dies. Those things you have to understand very carefully. And when you are doing your valuations, I think there are certain systems to value the freehold and life interest, the combination. So those things you'll have to master yourself, right? As far as the law is concerned, when there is a life interest, the owner is the person who has the deed title, but the other man who gave this land has the right to use it till he dies. For example, this man gifted this to his son. Right? Now, sometimes the deeds are written make a අවලංගු කළ නොහැකි කියලා ලියනවා. නැත්නම් අවලංගු කළ හැකි කියලා ලියනවා gift එකේ. මොකද එහෙම ලියන්නේ? මට තාත්තට ෂුවර් නෑ පුතා මේ මාව බලයිද කියලා වයසට ගියාම. ඒ වගේ වෙලාවට එයා දානවා ඒ කන්ඩිෂන් එක අවලංගු කළ හැකි ත්‍යාගයක් කියලා. දැන් අලුතෙන් ඇක්ට් එකක් ඇවිල්ලා තියෙන 1998 Mr. Dr. Vijaydatha Rajapaksa කියනවා. ඒ වගේ අවලංගු කළ නැහැකි වුණත් උසාවියට පෙන්වුම් කරන්න පුළුවන් නම් මගෙන් ගත් එක්කෙනා මට සලකන්නේ හරියට right ඒ වගේ අඩුපාඩු මට ඇති කරලා තියෙනවා ඒක නිසා මට නැවත ලබා දෙන්න කියන ඒ රයිට් එකත් අලුතෙන් ඇඩ් කරලා තියෙනවා so that means the life interest holder is protected under that act ඔක්ලාට මේකක් ලියනකොට ලියනවා මේ මට I want මේ දරුවගේ ආරක්ෂාව ඒ වගේම මට මගේ ආරක්ෂාව මාව රැක බලා ගැනීම මේ ඔක්කොම කරන තුරු මූට දෙනවා කියන අදහසකින් ලියන්නත් පුළුවන්. එහෙම ලියුවොත් තත්ත්ව වෙනස් වෙනවා. ඒ දරුවා මෙයාට දෙමව්පියාට හරියට සලකන්නේ නැත්නම් he can go to courts and get the gift cancelled. Right. Life and that be last මේක last will වෙනවා. no last deed මම කතා කරා. ඒකත් අපිට තියෙන information වලට ගන්න පුළුවන්. Name of owner, then name of the previous owner also there and the last deed. Right. Description of the property. අපි කතා කරා ඒක. Boundaries, price, consideration, testation, and the date of transaction. In a nutshell, what we discussed was there. Yeah, conveyancing is a different subject. That is, conveyancing is a procedure to be adopted in certifying and attesting a valid legal document by a notary that is called the deed. Conveyancing is used to transfer, gift, the ownership of a property by one party to another, to declare the ownership of person and to certify the exchange of ownership of the properties between two or more parties. Other transactions related to this. One thing I must mention here is that I'm not going to give a handout on this conveyancing, right? In Sinhala also, in Sinhala and Oppu, we may සිංහලෙන් තියෙන ඔපුළුවේ කාර්ය පටිපාටි කියලා කන්වෙන්ෂන් වලට ලියලා තියෙන ආනන්ද එන් තිලකරත්න ලෝයර්. ඒ වගේම ඉංග්‍රීසි පොතක් තියෙනවා කන්වෙන්සින් කියලා. ඒක ලෝ කොලෙජ් එකෙත් ගන්න තියෙනවා. Mr. Gamage. Right? That's also that is in English. To try to get all of that book better than this English one. Mr. Gamage, prominent lawyer, convincing කියලා තමයි පොතේ නම තියෙන්නේ. You can find it out. Law college available, and sometimes other bookshops also. Well, or else you can go to the Google and get some literature from that. The adequate literature is available in convincing. You have to collect those things and you yourself write a handout on this. Right. So this is one of the assignments that I am giving to you. I'll give it in writing later. That carries 10 marks. Right. I'll give you that. So you'll have to be very conversant with this area, conveyancing, right? And collect data and keep it. Then I'll tell you the time to write the handout. That's up to you, right? Right. මේ ටික මම කතා කරා ඉස්සෙල්ලා. Parts of the deed we discussed. Then we are coming to another important section, that is important terms. What is title search? Title search means, what is title? අයිතිය. අයිතිය සොයා බැලීම. කොහෙද අපිට හොයන්න පුළුවන් අයිතිය? From the land registry. Right? Ranjana. Ranjana is there?
Yes, sir.
Yes. Have you been to land registry? No. Okay.
Seen,
Doesn't
sir.
matter. And that means in the land registry, you have to go there and collect the important relevant transactions about this particular land. That is title search. Right. In the land registry, there are certain volumes. So directions they are given how to find out the relevant book. Say, for example, if you take a deed එකේ උඩම ගහලා තියෙන ඕගොල්ලන් දකින්න ඇති prior registration කියලා. Right? Prior registration. ඒ කියන්නේ මේ ඔප්පුවට ඉස්සෙල්ලා කරලා තියෙන registration එක මොකක්ද කියලා. මේ transaction එක හොයාගන්න ඕන නම් ඒ deed එකේ උඩ ගහලා තියෙනවා date of registration in that particular land registry. For example, we think it's Colombo. ඒ අපි ඩින් තියෙනවා සීල් එක ගහලා මේක රෙජිස්ටර් කරපු reference. Say for example A63/1. ඒ කියන volume එකේ 63 කියන 63 කියන page එකේ ඊට පස්සේ 1 what is the sub page you have to go. So that's very clearly given. Sorry, I missed that. A means the volume. Then say 60. 60 means the number of that particular book. A කියන පොතේ ඒ 6 අපි හිතමු 65. 65 කියන්නේ පොතේ අංකය. ඊට පස්සේ අපි හිතමු ආයි stroke 61 කියලා දෙනවා. 61 is the page. ඒකට ගිය ගමන් මේ ඔප්පුව හම්බ වෙනවා. ඊට පස්සේ එතනින් පටන් අරන් ඕගොල්ලන්ට ඒකේ search එක කරන්න පුළුවන්. That's a good exercise. One day you will have to do. Then what is title report? To write a title report, this is written by whom? This is written by a lawyer, not republic, right? Okay. Right. So the title report includes many things. That means now this deed is last year. That is 24. එතනදී අවුරුදු 30ක් විතර පිටිපස්සට යනකම් බලන්න පුළුවන් ඇඩ්මිනිස්ට්‍රේටර් ගියාම මොනවද වෙලා තියෙන transaction. Right? ඒ transactions ටික හරියට chain වෙලා තියෙනවා. සම්බන්ධ වෙලා තියෙනවා. කැඩිලා නැත්නම් you call it chain title. So the chain title is very important for mortgage purposes. Bank වල chain title එක නැත්නම් title එක මගදී කැඩිලා වෙලා තියෙනවා නම් they don't accept the security as a that land as a security for the mortgage. So that is important thing that you have to understand. So the title report is prepared from 30 years කාටද තිබුණේ then ඊට පස්සේ කාටද ආවේ what is the deed number, who wrote the deed, like that you are coming to the present day, right? So that is called the title report. After that a title report එකේ අනිත් පැත්තේ ගහනවා pedigree කියලා. Pedigree means පෙළපත් සටහන. ඒකෙදි මේ අපි title report එකේ තියෙන එක අපි sketch එකකට ගන්නවා. මම ඒක කරනවා වෙනම lecture එකකදී. වෙනම අපි ගන්නවා ඒක වෙනම sketch එකකට අරගෙන ඔය තියෙන ලියපු ටික ඔක්කොම summary wise, sketch wise අපි ඉදිරිපත් කරනවා. That's very clear. Right. So the title report is very important for the value. Why? Look at that. Ranjana, why it's important? Ranjana, I have one. කවුද ඉන්නේ? ලක්ෂාන් ඉන්නව නේද? ලක්ෂාන් ඉන්නවද? Oh, Samarkand,
Yes, sir.
my friend is there. Samarkand, quantity survey ඉන්නවද?
Yes, sir.
Yes, very good. Then why do you think අද අපි මටත් මතක නැහැ. Right. Important. Why do you think this is very important? This title report is very important for the professional. Any profession.
Because it gives the background of the property.
Yeah, that's correct. Yes. Now that means this title, right? You have to find out if the title is not clear, even the planner is finding difficulties to acquire this land. Right? The title, that's a small problem. So value, the title is there are some breakdown of some what you call is no connection. Right? Chain is cut, links of the chain cracked or whatever. In a situation like that, the title is very defective and you can't accept it as a good security for mortgage purposes, but that part is done by the lawyer. But as far as the value is concerned, he should have a good knowledge about to read the title report because he can understand the nature of the ownership, how it came up to now. So that is also very important for you to understand when you are carrying out your valuation work. Pedigree මම කතා කරා. Then the caveat. Caveat means සිංහලයේ තහනම් නියෝගයක් කියලා තියෙනවා. අපි ඒකට සිංහල වර්ඩ් එකක් මෙතන නැත්නම් කියන්නේ. caveat එක better to get used to Sinhala or Tamil words because that is used in the market. Okay. මගේ සිංහල වචනත් caveat කියන එකම තමයි පාවිච්චි කරලා තියෙන්නේ. So that means I can, my land is there, I can ask the land registrar, right, to inform me in case where a deed registration. මගේ මේ පෙළපත් සටහනට අනුව මගේ ඉඩම තියෙනවා මට අයිතිය. නමුත් මගේ ඉඩම් සම්බන්ධයෙන් ඊළඟ ට්‍රාන්සැක්ෂන් එකට යන්න ඉස්සෙල්ලා සමහරට වෙන කෙනෙක් ඒකේ රෙජිස්ටර් කරන්න ආවොත් ඒක මට දන්නන්න කියලා කේවියට් තහනමක් ගන්න පුළුවන්. ඒක රෙජිස්ටර් කරන්න ඕන අපි ගානක් ගෙවලා ලෑන්ඩ් රෙජිස්ටර් එකේ අපි කාල සීමාවකට ඒක තියෙන්නේ. ඒ කාල සීමාව ඇතුළේ කවුරු හරි රෙජිස්ටර් කරන්න ආවොත් රෙජිස්ටර් අපිට කියනවා මෙන්න මේ ඇවිල්ලා තියෙනවා. කියන එක කියනවා එච්චර. හරිද වැරදිද කියන්න මොකුත් නැහැ. ඇවිල්ලා තියෙනවා කියන එක. To get that information, we'll have to register KVL. List pendants. What is list pendants? That is, if there is a, say, partition case. So if I want to file a case, I have to go to land registry and register a list pendants. සිංහලත් ඒ වචන තමයි තියෙන්නේ. ඒක රෙජිස්ටර් කරනවා. ඒකෙන් දැනගන්න පුළුවන් මේ උසාවියේ නඩුවක් තියෙනවා කියන එක. ඊට පස්සේ ඒක උසාවියට දුන්නාට පස්සේ තමයි ඒ වැඩ කටයුතු පටන් අරගෙන ක්‍රියාත්මක වෙන්නේ. Okay. මේක අපි registration of documents කරනකොට කරමු. There are two types of registrations. One is title registration. Other one is registration of documents. දැන් ඔය ඉඩම් කන්තෝර වල කරන්නේ deed එකක් අරන් ගියා මේ document එක register කරන්න. But according to the title registration, they register the title. I'll come to that later, right? So that is the different types of registration. The land registry do the same work for both. Right. But the deed is okay. So my second part is the land acquisition act. Before that, I have to give you an introduction of title registration. Title registration, That is Title Registration Act number 21 of 1998. Just take down that also. You can refer that from the internet. Registration of Title Act number 21 of 1998. Right. So, later on you can trace this from the computer and Google or somewhere and read it and keep it with you. Okay. Yeah, this act is known as the Registration of Title Act number 21 of 1998. So that's perfect. That says this is the act to govern the registration of title. Okay. So that is the top person appointed by the act. He is called Commissioner of Title Settlement. Commissioner of Title Settlement. Commissioner of Title Settlement. Right. First of all, normally the registrar of title is the Registrar General. Registrar General තමයි ප්‍රධාන ලියාපදිංචිකරු වෙන්නේ title reports, title registration සම්බන්ධ. Not anyone else. Registrar. Right? So that power is delegated to the registrar in the land registries. That's a different thing. But he has that power. No one else. For Commissioner of Title Settlement කියන්නේ title කියන problems are solve කරන settle කරන කෙනා තමයි Commissioner of Title Settlement. So the main man is Registrar General of Title. So I'll just give you the procedure how to do this. Procedural accepts the method of registration. Registration shall be effected by entering the title register the prescribed particulars relating to such title. අර වගේම තමයි මේකේ title එක අරන් ගියාම මේක register කරනවා registrar by following a procedure. So the first and foremost thing is to prepare a cadastral map. Cadastral map. Cadastral සැලැස්මක් හදනවා. ඒක හදන්නේ survey general. Survey general inform කරනවා. ප්‍රදේශයක් දෙනවා. ප්‍රදේශයක්. අපි හිතමු දැනට දිවුල පිටිය ඒ වගේ ප්‍රදේශවල වෙනවා. ඒ ලොකු ප්‍රදේශය දුන්නාම he does aerial survey and take a big map and mark all the land parcels. Right? That's a big one. And there are so many lots. So that is the first and foremost thing. For the place where the title registration is being started. Cadastral map. Then, according to that, then after that this will be gazetted and the registration of each land parcel is done according to that. The reference is that particular plan that you have to understand very clearly. Yeah, when this is gazetted, that is the first part of the title registration. Then after that, when it is gazetted, after it is gazetted, there can be certain disputes and other things between the landowners. In that case, then the registrar of title settlement, right? He will go into that and try to sort it out after investigations. You got the point, right? Title settlement. Commissioner of Title Settlement, not the registrar, then right? Okay, then he does the investigation and give his opinion. Then after that, the registration of title will start. Right. In normal lands, the registration is done. Then after that, they study its title and they will give the nature of the titles. For certain lands, they give the first class title. That's perfect title, right? Freehold one. In certain cases, there are certain defective title. In a situation like that, they will give title 2, not title, class 2 level. So if it is class 1 level, there's no problem. At any time, the bank will accept that after doing some search or whatever. They will decide to give the loan. But if it is class 2, I don't say they don't give. They will give, but there can be certain restrictions and other things. Okay. So that is the normal procedure. First, prepare the cadastral map for a particular large area. Then after that is gazetted. Then after the Commission of Settlement investigate into that. If there are any problems between the owners and their extents, boundaries, etc. So once the settlement is done, that will be registered in the land registry. But before that, they give what the nature of the ownership or the title. What class 1 or class 2. That is given there. Okay. So those are important things that you have to understand in this title registration. You get all of this act and try to read it, right? Yeah, the important that you have to understand is in deed registration, there you register the document under registration of document ordinance. But in this case, you register the title. That is called the title registration governed by the Act number 21 of 1998. So that difference we have to understand very carefully. Those are very important when you are carrying out your duties of professional work in your career. Okay. Right, in page 25, that's the important thing given in this act. That is, they describe what land is. Right, we have been using this, the definition of land previous lectures. But here in this act also says land includes what? Land covered with water and any benefit arising out of any land. All things attached to the earth or permanently fastened to the land. So this very important clause for the valuers to identify what is land, what is immovable property. I think this also now you all agree with me. I have been telling you when I am doing the classification of things, what is land, the same thing, right? Then after that, during the accession discussion, I told you what is land. Land plus buildings and structures permanently fastened to the land. That what it says here. And also the things that are permanently attached or annexed to that particular building. So it's a very clear picture now on what land is, because we are dealing with land. Okay. So that's about the first part. I think we have some rest break now to come in about 10 minutes time. After that, we are going to start the Land Acquisition Act. I can do it within next half of the lecture period time. Okay.
Thank you, sir.
Okay. That's Land Acquisition Act as a mode of acquisition of ownership. I think I have sent you the handout. You may have got it now. So this is also one of the modes of acquisition identified as far as the legal concepts are concerned. In most of the other things, we identified the normal layman, right? They acquire land. But in this case, the government is acquiring your land. That is the difference, right? Okay, now we are going to discuss to understand the legal definition of compensation, because once the land is acquired by the government has to pay compensation to the affected party or to the person from whom the land was acquired. Second one, to study whether current methods of assessment of compensation is complying with such definitions. If not, propose guidelines to meet the rationale of equity principles. Next one, to identify the places where unjust enrichment arises in the operation of the Act. Relation to town planning, acquisition of land for planning work, etc. So this is a simple outline of we are trying to touch upon. Land acquisition as a mode of acquisition. The following statutes in the handout, you can follow it up. Following handouts made provisions to acquire the land under the Main Land Acquisition Act of 1950. So all these institutes make use of the Land Acquisition Act to acquire the lands for their purposes. What are the institutions? UDA, National Housing Development Authority, Mahaweli Authority of Sri Lanka, Mahaweli Lands Act, Colombo District Lowline Reclamation and Development Board Act, Sri Lanka State Trading Corporation, Ceylon Petroleum Corporation, etc., etc. Then Electricity Board also there, I think, that they are using this act to acquire and pay the compensation sometimes according to their norms, the compensation is different. That's a different thing. Then Land Acquisition Act number 9 of 1950 as a mode of acquisition of ownership. Section 2, section after that we can do the discussion of main things. Number 2, you can just read this and try to understand. That is the investigation of the land to be acquired, to see whether it's suitable for the proposed public purpose. Section 3 deals with compensation for any damage caused while in receival. Part 2 එකේ section 2 එක ක්‍රියාත්මක වෙනකොට වෙන වෙන යම් අලාභානි වෙනවා නම් ඒවල damages ගෙවන විදිය නෙමෙයි ගෙවන්න ඕනේ කියන එක එකක පෙන්නලා තියෙනවා. මෙතනදී defect එකක් තමයි ගෙවන්න ඕන basis එක දීලා නැහැ. The basis of compensation is not specifically given. That is also one of the points. Under the the compliance with compensation under equity. මොකක්ද ඒකේ compensation අපේ definition එක ඕගොල්ලන් දන්නවා මම කතා කරලා තියෙනවා. අන්තිමට තව පාරක් remind කරන්නයි. Section 7 is treated as the relevant date of assessment of compensation. ඊටම කවදාත්පත් කරගත්තත් section 7 නැත්නම් 7 වෙනි වගන්තිය ගැසට් කරපු දවස තමයි relevant date එක විදිහට ගන්න මොකක් සඳහාද? compensation ගෙවීම සඳහා. Section 9, inquiry on market value of land or servitude acquired by the action. Section 9 එකේ inquiry එකක් තියෙනවා. Acquiring officer, chief value or representative, and the claimants. ඒගොල්ලෝ එක inquiry එකක් පවත්වනවා. That is the main idea is to derive the market value of the property. So in that inquiry, the acquiring officer will investigate deeds and other things and try to clarify the level of title. Section 10. So may inquiry එකේදී identify කරගන්න බැරි disputes ඇති වුණොත් parties කීපයක් අතර then that will be referred to the courts. District court. එතනත් බැරුව ගියොත් that can be appealed to the Supreme Court. Number 17, section 17. Declare the amount of the section 17 එකයි section 9 එකයි අතර තමයි value එකේ part එක තියෙන්නේ. Understand? Section 9 එකේදී title එකකින් identify කරනවා, decide කරනවා. මේ අතරතුරේ කාලේ decide කරනවා value එක, compensation. Then after that, that will be declared at the section 17 inquiry. May sections can may act sections, right? Then we will come to the next one. Section 19. When the given valuation, say for example, section 17 එකේදී අයිතිකාරයට කතා කරලා කියනවා ඔයාට ඉඩමට ලක්ෂ 10ක ප්‍රමාණයක් ගෙවනවා. But the claimant is not satisfied. Then what is the solution for that? He can go to the board of review. That court, the board will decide, inquire into that, and decide whether compensation should be increased or not. Then this is another important thing. Section 38. Section 38 කාපුවම එදාට තමයි ආණ්ඩුවට මේ ඉඩමේ possession එක පැවරෙන්නේ. Once the section 38 is gazetted, only the government can acquire the possession of that particular land. Now you all know possession is only a part of the ownership. Right? So under section 38, possession එක පවර ගන්න එදාට. Then we are coming to the important section. Right. So the ඔයගොල්ලන්ට තේරුම් ගන්න මම එක දෙයක් කියන්න ඕනේ මෙතන section අපි 17 එක section 13 එක ගහන්නේ say last month. That is say 5th September 25. but the section 7 was gazetted early before that. So, for example, 1/1/25. So, even though this was vested in the government, September, valuation should be done as at this date. මේක ගැසට් කරපු දවසට තමයි 1/1/24 එකට තමයි valuation එක හදන්නේ. You can do the valuation as at the date of 38A. 38A. So that's a vital fact that you have to highlight. And there also you can understand certain discrepancies or some shortcomings because, for example, this was section 7 was gazetted 2 years back, for example, right? Then this was acquired after 2 years. Can't there be any difference in these values? 38 ගන්නේ අවුරුදු දෙකකට පස්සේ ඊට ඉස්සෙල්ලා වටිනාකමයි දෙන්නේ. මාකට් වැලියු එකේ වටිනාකම ඇත්තටම මෙදා අවුරුදු දෙකකට ඉස්සෙල්ලා ඊට වැඩි අඩු වෙන්න පුළුවන්. So that is also one of the things that we have to highlight here. The decreased value, right? Or in other words, අනිත් පැත්ත වෙන්නත් පුළුවන්. You can think of that, right? Section 7 එකට ඉස්සෙල්ලා අර ගන්න හදිස්සිය ගන්න ඕන නම් they publish section 38 and get the position, and later on after 2-3 years they will pay the compensation. Right? Those are the two things to be considered. Yes, section. Now we are coming to the next one. What is the definition of market value? Normal definition is the price fetched in the market between willing seller and willing buyer. The market is open market. So that price will be considered as the normal market value. But we'll have to go by the act, definition of the act. Market value is the price fetched, okay, right, in the open market. That's also correct. When sold by the willing seller as an entity. These two words, willing seller and entity, there's some that creates some problem. There is no willing buyer. And the other thing is, we'll forget about that. There can't be a willing seller because he doesn't like to sell this particular land. Right? So you can't apply this here. That's also one of the weak points from my point of view. I don't know. Then as an entity. Entity means if you purchased only a strip of land, say for road widening, 2 feet wide land, right? And length is say about 100 feet. When you put it to the market as an entity, what will be the value? And when you put the entire property to the market, say 10 purchase, it's a square shape land, what will be the value? So now you can understand the shortcoming, one of the shortcomings or the defects of the word entity, right? So as I told you, the strip, when you put the strip to the market, the demand is very low. The price is very low. So ultimately the person whose land was acquired is badly suffered. Right? So if you put that balanced land, say 8 purchase, purchase value is 10,000 per purchase. But when you put this strip as an entry to the market, no one will buy it. Sometimes it will be 1,000 per purchase. Sometimes maybe 0. It depends. So this is also one of the shortcomings that you can understand. So you jot down all the shortcomings when I'm talking, right? One of the shortcomings, the word entity is concerned, and there is no willing seller. He's not willing to sell his land. In fact, this act is now about 75 years. So therefore, you can't criticize those things. They have prepared as at that date. The conditions prevailed at that time, so you can't argue on that. But anyway, what we can see is some amendments should come very soon, or this act should be completely repealed or abolished, and new act should be framed. Understand? Yes. පොඩ්ඩක් පස්සට ගිහලා section 70 එකේ එක දෙයක් මට කියන්න අමතකුණා. Just tell you that section 17, this amount is say 5,000 rupees. That is government valuation. Relation department in I make 100. That is say 5 lakhs. But for example, this man is a very ignorant man, right? He has no much knowledge on these things, and he claimed only 4 lakhs, whereas the government valuation is 5 lakhs. What will happen? According to the act, the amount that claim or the lower amount, government valuation and this one, lower will be given to him. If the government valuation is lower than the amount claimed, then the government valuation is given. If the government valuation is more than what was claimed, then again the claim is allowed. So therefore, that's also one of the things, unfair thing. That is, I don't know why they have included this, but anyway, it's there. So I have given some example in the handout, page 2. State valuation, 1 lakh. Owners or the claimant. Claim is the owner's claim. CLIM, 90,000 rupees. So the loss to the claimant is 10,000. The actual market value is 100,000, but only 90 is allowed because according to that, the lower amount should be allowed. That is unfair. On the other hand, state valuation is 90,000. He claimed 100,000, but still he is paid only 90,000 rupees. And you can see how government is unjustly enriched at the expense of this poor person whose land was acquired. You understand that? Unjust enrichment කියන අයිතු සහගත ලෙස පොහොසත් වෙන්න පුළුවන්. කවුද වෙන්නේ? ආණ්ඩුව. අයිතු සහගත. Actual value is not given to this man. It should be given. Okay, so you note down these things. So the amendment or the improvement of that, these are very important. So here the government, the both instances, client is losing and the state is unjustly enriched. Here the unjust enriched 10,000. 10,000 rolling Raja unjustly enriched, and this man is lost by 10,000 rupees. Both cases. Then again, section 45 මම පොඩ්ඩක් කතා කරන්න තියෙන එක මම හිතන්නේ මම කතා කරා. Okay, page 3 I'll just go through that. That is also important. Market value of servitude shall. Servitude means paravashyatavak, right? Right of way wage දෙයක්, right? Where it is a new servitude which is to be created by its acquisition under this act, be the amount by which the market value of the servitude, Soviet tenement, will be dismissed by the creation of servitude. So ඒක මම servitudes කරනකොට මම ඒ value කරන විදිය පොඩ්ඩක් කතා කරන්නම්. Servitude means අපි right of way එකක් නැති වුණා නම් මේක අත්පත් කර ගැනීමෙන් තව තැනකින් ඒ right of way ගන්න යන වියදම අත් වශයෙන්ම මේ පුජ්‍යලයට ගෙවිය යුතුයි කියන එක. It's very simple, you can, right? There's nothing to argue, but that's there. That is servitude. So government, the act says you can acquire the land and servitude. Okay, දීලා තියෙනවා act එකේ පැහැදිලිව. You are going to acquire not only the land, the servitudes attached to the land. එකත් එක ගත්තා නම්. So you acquire that, then sometimes that can be a sort of landlocked land. So to purchase the purchase price of the servitude that is going to be purchased, that has to be purchased, as a result of this acquisition, that amount should be paid to that person. Another restriction is now, after gazetting the section 2 or 4, you can't sell the land. That is also one of the restrictions on the ownership of the land. When I was talking about the restrictions on ownership, right? So I think I came across this also, but anyway, I want to rewind this here. That is, yes. Yeah. After that, you can sell the land. Another thing you have to understand here is the problem, page 3 problem. Under the above definition, acquiring officer or the valuation department value the property, but why acquiring officer awards the amount in the event where the claim is less than that. Due to the ignorance of some other factors connected with the claimant, state unjustly enriched at the expense of another. It was a valuation as at section 4 is අපි તો date එක දීලා තියෙන section 4 එක තමයි. section 4 ගහලා තියෙන date එක. ඒ වටිනාකම තියෙනවා ඉදමේ 1 lakh. But section 7 was published after that. Now, actually, when you put it to the market, for example, no one will buy that because section 7 is published. Then people came to know that this is going to be acquired. But still, the government will assess this as at the section 7. That is 1 year later than 4. So that is also one of the defects that you can highlight. Then section 46. That is very important one. That's very important one. Assessment of compensation. Market value decided under section 45. 45. Right? 45 plus subject to the maximum of 20% of the market value for injurious affection and severance. Is this realistic? We have to decide, right? So sometimes once the land is acquired, the balance land, the loss to the balance land will be paid, but only the 20% of the value of acquired land. එතකොට අපි acquired land එක strip එකක් නම් ඒකේ value එකත් අඩු වෙනවා. ඒකනේ 20% maximum subject to the maximum of 20%, only will be paid to this man. So do you think this is reasonable? Practically, no. Okay. Then that is for injurious eviction and severance. එක බෙදාවෙන් කිරීමෙන් වෙන පාඩු නැත්තම් ඉන්ජරි එකක් වෙනවා නම් balance land එකට මේ 20% කියන්නේ මතක තියාගන්න. Then in addition, an average net rent of 3 years from the said business, the cost of shifting will be paid. That is a different thing. Then we are coming to the section 47. Section 47 is also very, very important one. Yeah, now, well, handout take from පොට්ටක් එක දීලා තියෙනවා. Yes. Right, so the compensation under 46 will be, we'll say C is equal to, C is equal to market value plus IA, injurious affection, and severance, plus loss of income, then plus cost of change of residence. That's a normal equation, right? Before coming to 47, before coming to 47, that is the equation you can formulate. C is equal to MV plus IA plus CS, cost of shifting the residence over there. So that's there. Now we are coming to 47 එක මොකක්ද කියන්නේ? Section 47. That is called the betterment. Betterment means if there is an increase, there's an increase in the balance land as a result of the acquisition of the front land. Right? Government think there that particular owner is unjustly enriched at the expense of the government's acquisition. පැහැදිලිද කියන්නේ? මෙතනදී ආණ්ඩුව හිතන්නේ මේ 120ක් maximum එකට යටත්ව තමුන්ගේ compensation එකකින් අඩු කර ගන්නවා 120ක්. Why? Because government thinks that the balanced land value has gone up due to the acquisition of the front land. That is the assumption. Whether correct or wrong, that is the assumption. So the 20% maximum. So from the 20% gane compensation. You got the point? That is the market value compensation. Right? Market value. Yeah. This is also one of the problems you have to visualize. Here the government unjustly enriched at the expense of this poor man. Because he's giving only, he's deducting 20% from that, from the balance. Sometimes value may not go up. Due to the acquisition of the front line, value may not go up. But still, due to some, the lack of knowledge and other experience and other things, you cut 20% from that also. That is also some sort of what you call unjust enrichment from state side. Another thing that we have to understand here is page 3, section 47 එකට යටින් තියෙන problem. Due to such acquisition, land values in the vicinity may go up. This financial advantage is enjoyed by the adjoining landowners and not the landowner whose land was acquired. So this is the argument. That is when the, say for a land was acquired for development project, right? So the adjoining landowners take the advantage of that. Adjoining land values are going up, but government is silent. He is not going to extract or get the what do you call the tax from that. But on the other hand, the government will cut 20% of the compensation, thinking that the value of balanced land is going up. But all the adjoining lands are high in value due to this development project or whatever. Government is silent on that. So this is also one of the important things that you have to look at. Section 48 එකේ කියන පොඩි problem එකක් තියෙනවා. There the any increase which is likely to occur in the market value of the land by reason of the use to which it shall be put after the acquisition, under that will not be considered for the valuation. එතකොට future එකේදී අනාගතයේදී ඒ ඉතුරු කොටස් වල වටිනාකම වැඩිවීම සම්බන්ධයෙන් කිසිම සැලකිල්ලක් ගත යුතු නැහැ කියලා තියෙනවා valuation එක කරනකොට. That is prospective the enhancements of the value, right? So they are ignored. මේක අත්පත් කර ගැනීමෙන් වැඩි වෙන වටිනාකම් පිළිබඳව සැලකිල්ලට ගන්න එපා කියලා section 48 එකේ තියෙනවා. That's also very unfair. This thing. Some of the first bit of then again, you are coming to section 48F. No improvements are compensated that were done after section 4. Section 4 එක ගැසට් කරායින් පස්සේ කරන ලබන improvements කිසිම දෙයකට ගෙවන්නේ නැහැ කියලා ඇක්ට් එකේ කියලා දෙනවා. ගෙවන්න එපා කියලා කියලා දෙනවා. That is the general procedural aspects and some technical points in the act as far as the important sections are concerned. So you'll have to be much conversant on the act, right? So now we are coming to some decided cases, few cases. I'll go. That's in the handout, you can read that, right? I make it land section 65, land is defined as follows. It includes interest, activities, other persons' grounds, and attach the things that are attached to the land permanently fastened to anything attached to the earth. So now you can see land definition. Definition of land is more or less equal in all the acts and the statutes. Right? So it's a very important thing. So because you all are dealing with the land, right? So therefore these are very important areas, so you'll have to be much conversant. So the important sections I have mentioned here, you have to refer. 2479-17, 38, 45, 646, 48, and 63. That's not in the handout. I think you'll have to just take it out. අනිත් එකට cases වලට යන්න ඉස්සෙල්ලා පොඩ්ඩක් අයිත් පාරක් කියන්න. Definition of compensation. Livingstone versus Reliance Coal Company. In setting a sum of money to be given for the reparation, you should, as nearly as possible, get at that sum which will put the party who has suffered in the same position as he would have been in if had not sustained a wrong for which he is now getting his compensation. Read carefully and try to understand that. What it says is, we should pay the amount of money that is adequate to bring that person to the same level as he was before such damage was caused to him. නැත්තම් ඒ පුද්ගලයාට කිසිම පාඩුවක් වෙන තත්ත්වයක් හිරියරයක් ඇති වුනේ නැහැ කියන තත්ත්වය සලකලා බලලා ඒ තත්ත්වය උඩ තක්සේරු කරලා definition. But this is not applicable in the statutory valuation. So that's also one of the defects you can highlight. Right? Legal definition is this, but Acts has not considered that particular area in framing the method of compensation. Again, there is another case on versus Underwood. Compensation that will give the suffered party reparation for a wrongful act and for all natural direct consequences of the wrongful act. As far as money is concerned, money can compensate you. Compensation should be equitable, sufficient to bring the suffered party to the same position he was before such damage was caused. So this is also one of the defects. The real compensation is this, but the statute pays something less than that. Okay, so if you are going to amend this act, you must try to incorporate these definitions and concepts in the act. Before going to the cases, I'll just give the recommendations. Compensation should be equal to the actual loss. Suffered party should be brought back to the same position he was before the damage. Value to the owner is also a good concept to be adopted here. And also we'll recommend to do some required amendments to the Act. So in a nutshell, we'll try to understand the sections as far as the procedural concepts are concerned. Then also we'll try to make some technical discussion on the compensation, market value, compensation, betterment, etc., etc., and the shortcomings that are cropping up in those areas also, we tried to highlight. We'll discuss some cases. After that, we can conclude today's session. Yeah. Now, legal terms of market value, page 4. We'll come to the second case, GA Southern Province versus Ceylon. Read that case. I'll give you 2 minutes and try to understand the what you call these facts of the case and the decision. Silently read for 2 minutes. So that's a very good guideline for the valuers, right? You better read that carefully. That the second part is that the Vida J said that market value of the given land depends on the extent, situation, relative position, and adaptability for any particular use. Very important. Also, upon rent and rate of interest obtaining in the district, right? Or in other words, he's inducing some sort of investment method, right? That is based on the rent. That is what I meant here. And among the test market value of a piece of land is a price which anyone would give for it at a public auction. බලන්න ඒ කේස් එක පරණ කේස් එක ඒ කාලෙත් ඒක දීලා තියෙන්නේ මේ මාකට් වැලියක වෙන්න ඕනේ මේක ප්‍රසිද්ධ වෙන්දේසියක වින්න ගන්න. පාටිස් දෙයක් එකතු වෙලා වෙනවට වැඩිය ප්‍රසිද්ධ වෙන්දේසියක් කියන්නේ that is a competitive market. මේ බිඩට වැඩි අරය වැඩි කරන competition. So in a competitive market, right? What would be the price that would fetch for a similar land? That should be the basis to be adopted. So that is very clear-cut case. Read it. 7, then Stephen versus Manusingha. So there the concept of best use is given there. You must, what is the best use you can put this land, and that basis should be taken into consideration when you are paying your compensation. 3, that is before that, our act is in 1950. This is 1903 එකේ මොකද්ද බලන්න. Discuss the dispute between the government and the applicant often arise in the amount of compensation. The lands tribunals acts as a judicial body to resolve the dispute and determine the amount of compensation that is payable to the applicant. Valuation survey always claim valuation is an art, not a science, and hence there is inherent subjectivity or human basis to be followed. So that clause is very important. So that says should be a very reasonable valuation. Is professional values point of view, it should be a reasonable one. Then again, the Livingstone versus Strayland, the case we did, that is there. That says what compensation is. Then you come to the very important case. That is Municipal Council of Colombo versus Lakshmi Chetty. Okay, පොඩ්ඩක් කියවන්න විනාඩි 2ක් 3ක් අරගෙන. It was important facts are there. I'll discuss those things. Just read for about 3 minutes. I'll give you 3 minutes. And try to gather the facts of the case. මේකේ කරුණු මොනවාද කියලා ඉස්සර තේරුම් ගන්න. ඊට පස්සේ අපි analytical analysis එකකට නැත්නම් analytical talk එකකට මොකද්ද වෙන්නේ කියලා බලන්න. I'm referring to page 4, Municipal Council case. මාකට් වැලියු කියන එකත් එක්ක මේක පොඩ්ඩක් එකට කියවලා බලන්න. What are the places where these two what do you call this market value definition and the case? What are the places where it conflicts? Okay, now there are the facts. What are the facts of the case? A land was acquired for road widening, 1903. A strip of land, very long land, where the width is small, or 30 feet or something like that. I can't remember, that's not given here. But anyway, this was acquired by the government. So the valuation was based on what? On the market value. The market value, yeah. Market value මොකක්ද කියන්නේ? Market value means section 45. Market value says, market value is the price fetched in the open market when sold by a willing seller as an entity. By a willing seller as an entity. අන්න මේක තමයි ගන්න තියෙන්නේ. As an entity. එතකොට අපි මෙතන කේස් එකේ මොකක්ද උනේ? Strip was acquired and valued as an entity. That as a strip they valued. So when this was taken to courts, district council decision was that it is reasonable to value this as a strip and compensation should be based on that. Then this was appealed to the Supreme Court. Supreme Court deviated from that slightly and gave its decision. Then again, those days the Privy Council was the apex court, highest court, Privy Council in England. This was taken there. That is why I say this is a very important case. Even this is before that. So when it was taken to that, again the Privy Council restored the decision made by the district court and said, yes, you must value it as a strip. Why? Because the act says you must value it as an entity. So the entity principle was accepted in this case. Right? So that is why I asked you to study the market value definition and the application, its application in this case. So finally, the decision was the entity principle is liable and it should be applied. You must go by that. That is what it said. Okay, that's normally when the land is acquired, valuation එක disclose කරනවා. After that, if it does not like, you can go to the board of review. එතරම් බෑගුවොත් ඊට පස්සේ යනවා අපි ඉහළ උසාවියට. So that is the procedure as far as the compensation is concerned. And okay, now the recommended guidelines for compensation in United Nations on compulsory acquisitions. That of course you can read it. I'm not going to read everything here. Yeah, now the recent trend is that instead of payment of compensation, you will give some alternative accommodation residence like that. So United Nations, they say that that's called the resettlement. Okay, some say, for example, one land was acquired and it was occupied by a fisherman and the family. Then they try to accommodate them, they try to shift them to a certain place and keep them there. So that is the principle. But here the problem is sometimes you can't uh, equalize those things. As for example, this man is living from the sea fishing. But if this land was taken over by the government, they were accommodated somewhere there, interior. So this man has to come to the sea to go for fishing. It's troublesome. And he has to bear some transport cost, etc., etc. And the schooling of the children, that's also a problem. Sometimes my school but when they were taken outside, then again, schooling is a problem for the people. And they lose some their social context. Relations are, they are missing relations. So those are the things that will happen. Bad things happen, not bad. Some minus or the negative things that will happen in these applications. Yeah. Resettlement in details you can read it, right? Resettlement problems again financially, socially, when the problems discuss right? So in a nutshell, in the court always prefer to go by that. That Kalam Municipal Council is the decision was the very important one and critical one that was decided by the Bay Council. It accepted the what do you call this entity principle. It should be valued as it is. That was allowed. So you can see even the courts always prefer to the provisions of the act rather than going outside that. So therefore we'll have to stick to that. So and another important thing, the last thing I have to tell you, that is section 63 of that. So in this section says that the minister can make some regulations to the act. For what? Can be used only for the purpose of implementing the contents of the act. The main act can be changed only by amendment passed by the legislature. Then presently situation is different. Some regulations were made deviating from this, and they are giving the full market value. The entity principle was rejected by the regulation, but that is illegal because regulations cannot do that. Regulations can be implemented only for the purpose of implementing the contents of that. Market value එක තියෙන විදියටම ඒ ක්‍රියාත්මක කරන්න කොහොමද කියන එක බලන්න. තව example එකක් ගත්තොත් අපි හිතමු border free එකේ වැඩ ප්‍රමාදයි. අභියාචන මණ්ඩලය. එතකොට ඒකට තව implement කරන්න ඉක්මනට එක්ක තව members ලා වැඩි කරන්න පුළුවන්. ඒ වගේ දේවල් කරන්න පුළුවන්. That can be done by the regulation, but you can't change the market value and the injurious affection. Entity principle, you can't do that. That's my view. I don't. I am also as a lawyer. I have studied this thing, but according to the Act, Section 63, we have to abide by it. But the people are not protecting. Even we are not protecting because protesting because this will be an additional advantage for the people. Right? In fact, market value is not reasonable. Right? So the regulations cannot amend that, but anyway, the present system is reasonable from that point, social point of view. People are suffering. People are suffered by this act, and some steps have been taken to what you call the remedy, to bring some remedies to the affected parties. So the parties lost their financial and social context and other things. So therefore, we'll have to be very careful. And I propose you all to write an essay on the act, not an assignment, right? By highlighting the shortcomings of the present act, right? And you are asked to suggest some proposals to bring this act to the present day level, because this is about 75 years old act. So therefore, I invite you to write that, take down this question. Write an essay. No. Assuming that you are appointed, as a member, appointed as a member, to make some suggestions to overcome the shortcomings of the present Land Acquisition Act. With reference to the methods of calculating the compensation, to preserve the rights of the claimants, as far as the losses to the claimant are concerned. So that's then we are also required to identify the places, not the places, the sections of the Act where there is unjust enrichment and losses to the parties concerned. guideline. Next line, guidelines. Carefully read important or the highlighted sections or the provisions of the act. And find out the defective nature of them. Defective nature of them. As far as the current act is concerned. As far as the current act is concerned. Next line. Discuss within brackets page 5 of handout. Discuss recommended guidelines for compensation by United Nations on compulsory acquisition and compensation. You are also required to examine. You are also required to examine how far the legal definition of compensation complies with the compensation calculated under the present act. Okay, I take about 5 minutes time to discuss in nutshell what we have done up to now. Otherwise, you are going here and there. First of all, we discussed about the deeds and its importance and how far it's relevant for the valuers and other professionals. Deed. And we also identified that the legal instrument of another mode of acquisition was the deed. Right? So the deed was the legal instrument as far as another important mode of acquisition is concerned, that is purchase or land transaction. And also we try to understand what are the requirements of a valid deed, and how does the Prevention of Fraud Ordinance regularize its procedure. We did that also. Carefully we discussed. Then after that, we came to the types of deeds and their purpose, and also at the same time, the parts of a deed. Parts of a deed. If you understand these things, very easy to read this and understand. For what? To get the real interest of that particular property you are going to value or use or do the development as a property developer or whoever. Then we try to understand the important sections incorporated in the deed as far as the professionals are concerned. That is especially in the operation part. So like that, we try to gather certain or cluster some important information and try to build up this discussion to a certain level. Then after that, we try to, the second part, in between first and second part, we try to understand, in short, the registration of title. And we try to understand the registration of title from or distinguish the registration of title and the registration of documents. We also briefly visualized or identified the procedural aspect of the Act. Finally, we came to the Land Acquisition Act. As I told you, very old act, but anyway, we tried to understand their defects and the shortcomings. And as master students, we tried to think from a different angle to bring this act to the today's level and update that, right? By eradicating all the unnecessary and inapplicable things to the today's concept of the society. As far as especially the compensation and in relation whether it's complying with the legal definition or not. If not, we have to improve that. So I gave you a long question. If you write a good essay on that, you will get a very good idea of the Land Acquisition Act and what are the improvements that you can do to update this Land Acquisition Act. So that was the summary that we have discussed today. So I'll stop it today here. So next time we'll come with a new topic. Right. In the meantime, I wish you all the best and thank you very much. We'll meet next week.
Thank you, sir.
Thank you.
Thank you.
Okay.
Thank you, sir.
Excuse me, sir.
Okay. Thanks a lot.
Sir,